I'm DJ Jeyaram, and as Jade said, I'm a special needs estate planning attorney. I'm going to share my screen with you in a minute, and what I'm going to talk about is special needs planning, special needs trusts. And as I was reviewing my presentation, one of the things that I would say whenever I gave this presentation is, every special needs parent's kind of biggest question, biggest concern, what keeps them up at night is who's going to do all the things for my child that I do if something happens to me. And that a good special needs plan is the answer to that question. And as I was looking at the presentation, I'm like, well, I need to say why. And so when we were kind of promoting this presentation, we talked about benefits protection. And so things like if you have Katie Beckett, if you have Medicaid for your child, if you have the now comp waiver, or really any of the Medicaid waivers, what's so important about a special needs trust and estate planning is to make sure those benefits continue. There are other things we're going to talk about, obviously financial support and functional support, who are the players in the plan. But those Medicaid benefits are just critical. And as our special needs kids kind of get a little bit older, if we're here, that's great. But right now, under the law at 26, they age off of our insurance. And so unless we can afford an individual policy for them, that's where Medicaid preservation becomes so important. So let me go ahead and share my screen with everybody, and we'll kind of get started here. Okay. Like I said, we'll talk about mostly about estate planning, but how that functionally is going to help if something happens to one or both of the parents. I do have to say this, obviously I can't address everyone's particular situation on a presentation like this. So anything of what I'm giving you is just general advice. It's not specific legal advice to you. If you have any questions, I'm going to take questions at the end. You're always welcome to email me. I'll give you my email address at the end of the presentation. Just a little bit about me. I've been, the years fly by. I've been practicing for 25 years now. I've got 11 years of judicial experience. I am currently also a magistrate judge in Gwinnett County. Went to Emory Law School, but really the most important qualification I think I have to talk to families is this. As Jade said, I'm a special needs dad as well. This is my son, Kai. Kai's 13 now. He's a little bit younger in this picture, but we're on the Katie Beckett program. We're on the now comp waiting list. We've sat through the IEP meetings. He gets something like 14 sessions of therapy a week. Everything I'm going to talk to you about, my wife and I live. And so Kai is the reason I got into this area of the law about a decade ago. And so every decision, every document we're going to talk about are things that my wife and I've had to decide. And I am always open to sharing with people, either one-on-one or even in a group, how my wife and I have structured things for our family. So do not hesitate to ask if you have questions. Okay, what are our goals today? What do we want to accomplish? One is just a basic understanding, a basic common sense understanding of all the documents that you really need in a good special needs estate plan. Some of them do overlap with a regular plan, but the nuances within the document, the details, do differ in a special needs context, and I'll go through that. Second thing I want to make sure we address is how to choose the major players in your plan. Your guardians, your trustees, your executors, and how all those people work together to kind of give your child the most secure future possible. And finally, how to know if the attorney you are talking to is the right one for you. I will say just right off the bat, special needs planning is a specialty. And so I would caution you about going to a general estate planner. Go to someone who really kind of works in this area. There are several, many of which give presentations at Focus who are excellent. But I'm going to give you a couple tips if you're interviewing attorneys, some things that they need to talk to you about. And if they don't, you may want to continue your search. Okay, this is our list. These are all the documents involved in a good special needs estate plan, in my opinion. Every document we have here is what my family has in place. I do not have anything in addition to what we have here. I'm going to go through all of the major documents through the presentation, but just to hit on them briefly now, obviously everybody needs a will. We'll go into why that is so important in a second, but you should have a will in place and a special needs trust. One of the things about special needs trusts, some families will come to me and say, well, DJ, look, we're not getting Medicaid. We're not getting Katie Beckett. Do we really need a special needs trust? Well, the answer is it depends on whether you want to protect your child's ability to get SSI and Medicaid in the future. And so, and again, we're envisioning a time when mom and dad may not be there. So, you know, if you're just using my family as an example, if Kai's 13 and he's not getting Katie Beckett, you know, I've had clients in my shoes say, well, do we even need something like that? Well, I'm looking down the road that if something happens to myself or my wife or both of us, that Kai's going to need those Medicaid benefits instantly because mom and dad aren't there to provide the insurance. Mom and dad aren't there to provide the financial support. So it's not just preserving current benefits, it's preserving future benefits. The next two documents, an advanced medical directive and financial power of attorney, are just very basic documents in any estate plan. HIPAA waivers, I'm sure everybody on this call has spent more than their fair share of time in doctors' offices and therapists' offices. You all know what HIPAA is. It's your healthcare privacy laws. And why a preemptive HIPAA waiver is important for special needs families. I'll talk about that. The next three documents are really informational. They're not legal documents, but in my opinion, they are critical to having a good plan. Financial information. What do you have? Where is it? And how does a surviving spouse or an executor get to it quickly so that it can be used for their support or the support of the child? So we talk about how you gather that financial information to make it easy for people. Letter to the guardians, that's just what my firm calls it. A lot of people call it a letter of intent. And this is really just about educating your guardians that if something happens to mom and dad, or even just sometimes one of the parents, does the surviving parent, or if both pass, the guardian who steps into the parent's shoes, know what to do with your child on day one, on day two? Do they have the knowledge about their meds, their schedules, sensory issues, specialists? And so I'll talk about an easy way to do that. The child safety and protection cards are the part of the plan that answers the question of, if I'm in an accident, what happens in that first 30 minutes, an hour? How do we get information to law enforcement or first responders to let somebody know that somebody has to go get my kids or look out for my kids? They aren't capable of necessarily doing that on their own. The last two are the trustee and guardianship designations. These are the major players in the plan. And these are, in my opinion, the hardest decisions in the plan. And we'll talk about how they work together, and I'll give you some tips on how the trustees and guardians, how you choose them. All right, let's jump into the wills. So the will, you're going to have a few major decisions in the will. First is, of course, the flow of your estate. How are your assets going to flow? In 99% of circumstances, if one spouse passes away, they want 100% to go to the surviving spouse. That's sometimes a little different in blended families. Sometimes if it is the birth parent who wants to fund a trust for the special needs child immediately upon their passing, but leave a percentage to the surviving step spouse. But the flow of your estate is one of the big ones. Where that really becomes difficult is if you have more than one child. You have a special needs child, and let's say you have a typical child like we have in my family. Well, you're going to have to decide how much are you going to leave to each child's trust for their support. And if you have littles, that's a really hard question. My typical daughter is 9, but you have to come up with one. You have to come up with an answer. Our hearts always say 50-50 because we love our kids the same. But the reality is one of your kids may have more challenges supporting themselves through life than the other. And so is that something you want to take into consideration? The flow of your estate is one of the major decisions you're going to make in your will. Guardians. If something happens to you and your spouse, who is going to step into your shoes to be guardians? We want to make sure we make this decision for ourselves. The hardest question I get from clients is, what if I don't have anyone? And my wife and I are faced with that similar challenge. It's a hard ask, especially if you have a special needs child that needs a lot of care, a lot of attention. You're really asking a lot of these guardians. If you have them, that's great. You're blessed. If you don't, like a lot of families don't, the very unsatisfying answer I have for you is you have to find them. Because if you don't make that choice in your will, a judge is going to make that choice for you. The judge is going to go down a statute in order of priority and try and contact those people in that order until they find someone who says yes. And we all have at least one family member that we may love, but we know we don't want raising our kids. And so we want to make sure it's very clear in our will, and the judge will look at that and weigh it very, very heavily. The judge will look at that will and say, okay, the mom and dad wanted this cousin, not necessarily a sibling, but we have to document that. The next big decision in your will is going to be your primary residence. What do you do with it? Your basic will just leaves ownership of it to somebody. Well, it's a little different in a special needs situation. In my will, it is very important for my wife and I that if something happens to both of us, that my kids stay in this house until such time that it's in their benefit to leave it. And the reason for that is my son has a pretty significant intellectual disability, but he knows the names of the rooms. He knows what's Kai's room. He knows what's Emmy's room. He knows the playroom. He knows, where the bathrooms are. It's his comfort zone. I mean, think about how much comfort your child gets from your house and their stuff and their yard and their play set. And if something happens to mom and dad, obviously that is the biggest part of their life changing. But then if your plan is to have them go live with the guardian, which is perfectly fine, just realize you're also changing that, right? You're changing where they're living. You're changing their yard and their room and the neighbors. And so it's definitely something to think about. If your plan is for them to go live with the guardian, then you may want to be specific in your will and tell your executor, I want you to sell the house because that's a major financial asset for us, and we want it used to fund the trust for the kids. Or if it's important for you to keep the house, then you have to let your executor know that. Look, we want you to keep the house. We want it transferred into the special needs trust. And we want to make sure that our child can stay there as long as they want to. But that's a plan. That's why it's called an estate plan. And those are two very, very different choices that we can't just leave up to the executor to make the best decision. We as the parents can make the best decision. And realize that no decision we make in these plans, none of it's permanent. As long as one parent is alive, you can make changes. So maybe you want them to stay in the house now, but down the road when Kai's 25, hopefully either my wife or I, or hopefully both of us, will be around. We can go in the will and go, okay, he really doesn't need to be here anymore. He's comfortable going other places, being with other people. So we can always make a change at that point. If you have business interests or property, what do you want done with that? A lot of small business owners out there, or people who have small businesses on the side. Interestingly enough, special needs parents, a lot of them, a greater percentage of them have their own business because of the flexibility it provides in helping us care for our kids and run to appointments. But is your business to be sold? Or is it to be kept and placed into a trust to be managed by the trustee? Maybe it's an income source for the trustee. For the trust. So maybe that is a decision you want to make sure you communicate to the executor up front and not just leave it up to them on what to do with it, because you know your business better than they ever will. And ultimately, who your executor and administrator is, you want to make sure you have someone detail-oriented who will follow the directions that you're going to give them in a well-drafted will or a well-drafted trust. So one of the things that, and I have it down here, but if you have a takeaway on why you need a will from this presentation, it's this. People are under the misconception that if they're two parents and one parent and neither parent has a will and one parent passes away, a lot of people are under the misconception that 100% of the deceased parent spouse's estate will go to the surviving spouse. That is not accurate. Under Georgia law, if a parent passes away without a will, part of that parent's estate, a sizable chunk of it, will go to the kids. Okay. Well, what does that mean if it goes to the kids? Well, it means one big thing. Even if your child is a minor or is over the age of 18 and you have guardianship and conservatorship over your child, that money will go into a conservatorship for that child. But here's the important part. SSI and Medicaid see a conservatorship as the child's asset, no matter how old they are. And so if Kai's on Katie Beckett, something happens to me and I pass away without a will, well, guess what? A third of my estate goes to my wife, a third to each child. Not a big deal for Emmy. I mean, it is a big deal because she'll get her inheritance when she turns 18, which is a terrible idea. But for Kai, he would instantly lose his Medicaid because now he has assets in his name. Okay. So it's not one of those things where you can say, well, there's no rush to put a will in place because something needs to happen to myself and my spouse before it affects the kids. That is not the case. So at the very least, you want to get a basic will in place, leaving your assets to your surviving spouse. Okay, let's talk about the special needs trust real quick. Well, not real quick. This is going to be the major part of our discussion. So what is a special needs trust? Most of you probably know, but just to make sure we're on the same page. What makes a special needs trust special is that any money you put into it, whether you're alive, whether you've passed away and it goes from your estate into it, whether it comes from an insurance policy directly into it, the government ignores the money in a special needs trust in determining your child's benefits. So back to that example that if something happens to me if I didn't have a will, some of it goes to Kai. Well, now I'm going to have a will in place and I'm going to have a special needs trust in place. And so my will or the trust is going to read, when I pass away, 100% to my spouse. Well, let's say Cassandra predeceases me. Well, then my will is going to say Kai's share goes directly into Kai's trust, special needs trust. And because that money never hits his hands, he never legally owns it. It goes directly from the funding source into the trust. He keeps his benefits. Okay, but that money in the special needs trust is there to support him through his life. All right, there's no loss of benefits. So that's what makes a special needs trust special. Government knows it's there. The trust is complying with state law and SSI regulations to qualify as a special needs trust. And you can have as much or as little money in that trust. There is no cap, but the government ignores what's in it. Okay. And that's how the second bullet here, you protect your current and future benefits by keeping assets and money out of your special needs child's name and putting it in the trust for their support. Okay. This third bullet, we just talked about what happens when one parent dies without a will. Okay. All right. So let's talk about the big picture. We know what a special needs trust is for. It's to protect benefits by keeping assets out of your child's name if something happens to a parent. There are three major kinds of special needs trusts. There's something called a first person special needs trust. Bottom line is you don't want this if you can avoid it. What a first person special needs trust is that whatever is being used to fund that trust is already owned by that special needs child. It's already in their name, or they're all already legally entitled to it. Okay, but we're taking that asset or that money out of the child's name to requalify them for their benefits, and we're putting it in the trust. Okay, that's first person because it's coming from that person directly into the trust. The downside to a first person trust is that at the end of that beneficiary, that child's life, to the extent Medicaid is paid for anything for that child, any services for that child, Medicaid can take what's left in the special needs trust. Okay, it's called Medicaid payback. Now let's contrast that with a third person special needs trust. This is what you want. A third person special needs trust, like I explained before, goes directly from the funding source, whether it's your will, whether it's you, whether it's your life insurance or a bank account, it goes directly from that source. It bypasses the special needs child and goes directly into their trust for their support. Because the child never legally owned that asset or those funds, at the end of the child's life in a third-party special needs trust, that money goes wherever you want it to go. So when if you have more than one child and you're kind of managing your finances to make sure both are supported, obviously you'd rather have that money go to your surviving child instead of back to Medicaid. And to do that, you have to plan ahead. You have to have that third person trust ready to receive funding in some manner. And I'll go into what some manner means in a second. Okay, so third person is what you want. There is something called a pooled special needs trust. It is right for some people. I don't spend a lot of time on it because I don't particularly like them, even though they are appropriate for some people. What a pooled special needs trust is it's a giant existing special needs trust managed by a professional trust company. And what you would be doing if you wanted to utilize the pooled special needs trust as your special needs trust for your child is in your will or in your funding source, you will direct those funds into an account you've opened for your child or your executor opens for your child to hold those funds and those assets. But with a pooled special needs trust, that trust company is one of the trustees of the trust. So they have control over the trust, over the funds. And you don't have any say in how the trust is drafted or how that money's to be used. It's kind of a lowest common denominator trust because they have to have a set of rules that apply to everybody who holds an account. So for some people, it may be a decent choice if you're the size of your estate, and again, that includes houses, life insurance, bank accounts, 401ks, all of that. If it's minimal and it doesn't seem like it's worth it to pay an attorney to build a third person special needs trust for you, the pooled trust up front is a cheaper option. In the long run, because obviously you've got to pay this trust company to perform this service for you, in the long run, it does turn out to usually be more expensive. But in the short term, it is less expensive to kind of open up the account and have it ready to receive funds. Okay, so how do we actually create the special needs trust? All right, we know what it's for, to protect benefits current and future. We know the kinds out there: first, third, and pooled. We don't want a first. If we can avoid it, sometimes you can't, but we want a third because we don't want that Medicaid payback. And then pooled might be appropriate for some folks. But how do you actually make the trust? Well, the process of making the trust, you really have two options on how that trust is made.
Jeyaram, sorry to interrupt. I have a question.
I'm going to go ahead and take questions at the end.
Oh, got it. Yeah.
Just to make sure I get through everything. But I'm glad to stay on the line as long as I need to. Okay, so with the special needs trust, how's it created? You've got two ways to create it. One way is you can build it in your will. So there'd be a section of your will, and if you have a spouse, your spouse's will, that says, upon my passing away, I want these assets to go into the special needs trust that is created through my will. Okay. That trust is not alive. It is not ready to receive assets until you pass away. The other option is you telling me, DJ, I don't want to wait till I've passed away to have that trust ready. I want it ready right now. So I can put money in it. Or a grandparent might be able to put money in it. Or even not, if not put money in it, that grandparent can name it in their will to leave some of the assets for when they pass away into that special needs trust. The way we do that is we call it a standalone trust. It's also called a living trust. We take your trust and it is completely separate. It stands from your will. It stands alone, aside from your will. And it springs to life as soon as you sign it and you put $1 in it. Now, there are pros and cons to both choices. Really, the only big pro to the testamentary is it's less expensive from a legal fees drafting point. Because I'm not building something separate for you. I'm building something into your will. Some of the pros of the standalone is, one, it tends to be significantly more detailed than the testamentary. It's longer. A standalone trust that we draft, depending on decisions you make, can be 25 to 35 pages long. It has examples in it. It has every power of your trustee laid out. And you as the creator of the trust can go in and remove powers if you want. While the testamentary trust is not quite as detailed as that, because that testamentary trust is in the will, and that document is primarily your will. Other benefits of the standalone is, like I had said before, a lot of times you have grandparents or other parties who may want to name the trust in their will to leave assets when they pass away. Well, it's likely that the grandparent's going to pass away before the parent will. And so if you have a testamentary trust, but you're still alive, if the grandparent named that testamentary trust in their will, it won't exist because you're still alive. The standalone trust exists. And so if that's named in the grandparent's will, whatever the grandparent wants to leave can flow directly into that standalone third-party trust. But bottom line is you have options on how it's set up, and an attorney should be able to explain this to you. All right. So just very briefly, what can special needs trust funds be used for? What can't they be used for? You can't use special needs trust funds for food or shelter for your child without potentially affecting their benefits. The government, and when I say the government, these are the SSI regulations. And if you're getting SSI in addition to Medicaid, your child's also getting a monthly cash stipend or cash benefit. And government's position is, look, you use that cash for food and shelter, and then we're giving you healthcare and Medicaid. So we're giving you all the basics. And then if you're going to supplement food and shelter out of the trust, we're going to start dinging your cash benefit a little bit. Now, there are strategies around that. There's strategies to deal with that using an ABLE account. But just in terms of the special needs trust, you want to be careful that your trustee slows down before they use money for food and shelter, because it could potentially affect your child's benefits. So what can you use it for without worrying about affecting benefits? Anything else other than food and shelter. attendant fees, transportation, hobbies, education, pets, and basically, again, anything other than food and shelter. And again, you can use it for food and shelter. There's just a price to be paid. So it's going to be a balancing, a weighing, whether using the funds from the special needs trust from food and shelter whether it's worth it or not, whether the offset of the cash SSI benefit is worth that or not. So your trustee really needs to either have a basic understanding of that, or have your attorney's number handy, or a CPA or a financial planner or a benefits planner who understands the SSI regulations and the impact on your child benefits before the payment is made for food and shelter. Okay, it's one of those ounce of prevention, pound of cure things. You just want to know up front the impact on your child's benefits. Okay, so that's it for the special needs trust. That's functionally what you need to know. What is it? It's to protect your child's benefits: SSI, Medicaid, Katie Beckett, now comp. It's to protect your ability for your child to keep those things or to get them in the future. We know generally the types of special needs trusts: first, third, and pooled. You don't want first if you can avoid it. You want third or potentially pooled if that's the right fit for your situation. And we know how you create it, either in your will or outside your will. Pros and cons to both of those. And ultimately, we know what you can use it for and what you can't use it for. Just remember, I'm not going to spend a lot of time talking about this because it's not really technically a part of your estate plan, but an ABLE account does work with special needs trusts. They kind of supplement each other, they complement each other. I have both for my son, and so an ABLE account does play a part in your financial planning on how all this is to be covered, but is not necessarily a direct part of your estate plan. All right, let's just talk about guardians real quick, because this is where a lot of families get stuck. Briefly, who needs a guardian? Anyone under the age of 18, or someone who's 18 or older and who has been adjudicated by a probate court as incapacitated, meaning they cannot make decisions about their health, safety, and welfare on their own. Okay. If you are a parent and you have a child who kind of fits that description, you do not automatically become that child's guardian when they turn 18. When they turn 18, they become an adult in the eyes of the law. So if you want guardianship over that child to make sure decision-making authority remains with you, you have to go through the guardianship process, okay? Big question I get is, when do you start that process? 17 and a half is when you really want to start making your decision of whether guardianship is right for you, whether power of attorney as an alternative might be right for you. But that's when you really want to start giving it some significant thought. All right, a couple tips on choosing a good guardian. And this is where really pushing yourself in decision-making up front pays off. How old are they? Right? I get a lot of people choosing the grandparents as the guardian because they know the child the best. That may be a good choice, but you also have to think of, do they have the energy to do what needs to be done? I'm an older parent. I had kids later in life. I barely have the energy to do what needs to be done for my kids. And so I know my parents don't have that energy, and though they would want to, and though they would try, realistically, does your guardian's choice have the energy to do what needs to be done? And how do you figure that out? Well, look at your life and look at how much energy it takes to do what needs to be done, and then kind of look at the guardian, potential guardian, and see if you think they have that kind of energy. How is their health?
I'll take it.
Do they have health issues? Do any of their other kids have health issues? Do they have the time to do what needs to be done? Are they going to be taking care of elderly parents on their own? Again, that ties into the time and the energy to do what needs to be done. Couple big ones: location. Where does your guardian live? If it's important for your child to stay in your community, in their school, with the same neighbors, with the same therapists, well, then you want a guardian who's going to be in that area. Okay. If you choose a guardian who's outside of Georgia, you will lose, and your child goes to live with them. Your child will lose their Georgia-based benefits, and you'll have to reapply for benefits in whatever state they're moving to. Is that a big deal? I don't know. It depends on that state's law. If it's something like Now Comp, and we know in Georgia there's a long waiting list, well, maybe Tennessee has a similar waiting list and you'd have to start over from the bottom. We don't know, but it's something you have to think about when choosing a guardian who's out of state. And for me, a big one is, how do they handle stress? Our lives are stressful. They just are. There's no real other way to put it. We have a lot on our plates. And if you are naming a guardian who's kind of had a what I'll call a charmed life, suddenly become a special needs guardian might be a shock to the system and a change of lifestyle. And it'll be stressful. How do they deal with that kind of thing? When you are thinking about these things, about who to choose, this is not a time to worry about the feelings of your family, extended family, and the guardians, or potential guardians. A lot of people will tell me, look, I kind of got to choose my sibling or my grandparent because they would be crushed if I didn't. I said, well, look, you're hiring someone for the most important job you will ever hire someone for, raising your kid, while looking out for your child. I would encourage you to pick the best choice possible for that, regardless of whether that is, that sibling or that parent. So in my opinion, it's not really a time to worry about their feelings as much as, look, I need to pick the best person for the job. When you are choosing a guardian, we always encourage you to choose a guardian and some two or three backups to that person. Because if you have a younger child and you're choosing a guardian who's 50, well, that guardian might be a great choice for 20 years. But that guardian will pass away most likely before your child. So your backup guardian, instead of 50, you'd want that person to be 30. And maybe the backup to that person to be 25. Now you have a much longer lasting plan, longer lasting choices. And something that's very important both for this and guardianship, this and trusteeship. In a special needs plan, you want to have the mechanism by which successor guardians and successor trustees are chosen. The mechanism, even if you don't have the name of the person. The reason for that is if something happens to the last named person in your plan and they had not chosen their successor, well, then who makes that choice? Well, instead of going to a judge, we would want a mechanism built in. So for example, what I have in my will is that any successor trustee or guardian has to be agreed to, if it's for guardian, agreed to by the then acting trustee and my son. Likewise, if it's the trustee being replaced, the guardian has to agree on whoever the choice of the trustee is. So there's some oversight of someone who knows and cares about my child on who those successor trustees and successor guardians may be. All right. Just real quick, because again, I do want to leave time for questions. The guardian letter I had mentioned before, also known as a letter of intent. We have to educate our guardians that if they have to step into our shoes in an emergency, that they know what to do. And so what does that mean? Well, what to do is the basics of day-to-day care for your child. Is there a bedtime process? Is there a bath time process? To brush, we still have to brush my son's teeth. Well, he doesn't really enjoy us doing that. So we have to, we have to sing a song while we do it. It has to be a very particular song. And if it's not that song, he's not opening up. So I have to make sure I tell the guardian what that song is. If you have trouble getting calories in your child, do they have a special diet? Is there something when you need those calories in, you have a go-to food? Do you have to monitor their chewing to make sure they're choking hazards? Do they go to school? And if so, is someone picking them up? Is a bus picking them up? Are you dropping them off? What happens that day your guardian steps into your shoes or the next day? Do they have the information on what to do? And we have to write it down. The way my firm does it is as part of our questionnaire for you. There are a couple pages that you fill it out and we type it up into a guardian letter for you. We send it to you as a Word document. It becomes part of your plan. And we encourage you to send that to your guardians now so they can ask questions while you're still alive. An easier way to do it, which you do not need a lawyer for, and you don't need us for, is I would encourage everyone on this presentation, open an email address at a major provider. Please don't use Hotmail anymore. A major provider like Google or Yahoo, that's going to be around for a long time and has good backup systems. Open up an email address in your child's name. And if you have a bedtime process, a bath time process, a feeding process, a how I play with my child process, a how my child communicates to me, take out your phone and just video that. It's going to probably be a pretty short video. Video it, and as soon as you are done with that video, immediately email that to that child's email address that you had just created. And in your estate planning documents, we will put that child's email address and the password to that. So now your guardian doesn't just have a letter from us, but they have a visual. Oh, this is what it looks like to feed Kai, or to go through a bath time process or bedtime process or brushing the teeth process. That short video is worth, dozens of pages of writing. It's free, it's fast, and I would encourage you to do it. No matter what you do with the rest of your plan, that's something you can do today. It's simple and it is critical. The saddest thing I ever see from my judicial work is when you get people who are not prepared to step into the role. Their hearts are in the right place, but they just are not equipped on what to do. We have processes that we've come up as special needs parents just to make it through the day, make it through the week. Pass that on. Don't make the guardian relearn what you have perfected. The example I always like to give, because again, I'm kind of talking in generalities, but my son is what I call semi-verbal. He's got some words, but can't really communicate complex thoughts. But if he wants me to play with him in a particular way, he'll come up to me and say, "Daddy, Dunna." Well, if I'm gone, mom's gone, something's happened, guardian walks in, and Kai goes to the guardian and says, "Dunna," meaning he wants them to play with him in a certain way. Maybe it's to deal with his anxiety because mom and dad aren't there. I have to tell the guardian what "Dunna" means and how I play. If I don't, I've stolen his voice, and I've stolen that very important playtime for him, that coping mechanism for him. And in case you're wondering, Donna is when my wife or I will chase him around the house with his stuffed shark. Because when we chase him, we do the Jaws theme, the Donna, Donna. So doesn't say shark, he says Donna. And so, it's heartbreaking for me to think that if I'm not there and my wife's not there, that the guardian won't know that. So it's up to me to communicate that. So let's talk about trustees real quick. This is going to be the last major point I'm going to touch on, then I'll take questions. The guardian is over your child. The trustee is over the funds in the trust. I do not suggest that they be the same people, because they do act as a check and balance on each other, because the guardian is relying on the trust to provide for the child, and the trustee's only job in managing that trust is to look out for the welfare of your child. Well, by virtue of that role, they're also watching the guardian. Yeah, another way to think about it is after mom and dad are gone, even if the child, especially if the child has siblings, there are only two people, or two roles, I should say, that are legally connected to your child: guardians and trustees. If you make them the same person, you've now cut in half the number of people who have an actual active role in looking out for your child. I personally would want the two people, because what if something happens to the trustee or the guardian in their life, and they start not doing the job as well as I would have liked? I have to make sure I have an extra set of eyes on what's going on. Okay. There is a lot of other things in there. Tips and tricks on choosing a good trustee. Obviously, they have to be responsible. You need to trust them, as the title indicates. But they have, in my opinion, they have to care about your child. They have to care. They'll have to go the extra mile to make sure that child's okay. In my trust, I've asked the trustee, obviously the guardian will be living with my son, well, as he's younger, but I've asked the trustee to proactively reach out to the guardian every month, whether they hear from the guardian or not, just to say, hey, how's Kai doing? Does he need anything? Where we see the most indications of neglect, or sometimes even abuse, is when no one's paying attention. So the more people I have paying attention to Kai, the less likely those things will ever happen. I'm going to skip these other documents because these are basic in any estate plan. Advanced medical directives for the parents. Can also be for your child if you choose, adult child, if you choose not to do guardianship, you want an advanced medical directive. That's you appointing a healthcare agent. Financial power of attorney, who's going to handle your finances for you. Again, if you don't choose guardianship, but your adult child needs help with these things, they can appoint you as their financial power of attorney so you can assist them with their finances. We encourage you to carry emergency contact information with you. These are the cards we do for our clients. And it's basically, look, if something happens to me, these are the people I want you to call, because my child may be at school, they may be at a therapy, they may be at camp. But if they're a child who may not be able to communicate, or call dad, or call mom, or call the neighbor, we want to make sure first responders know who to call. Final advice, and then I'll take questions. Where people get hung up on this is they start talking about who's going to be the guardian or who's going to be the trustee. Hard choices. Do not get hung up on it. You make the best choice of the people you have to choose from today, knowing that that choice can be changed as long as one of you is alive. But if you don't make the choice, a judge is going to make it for you if that becomes a necessity. So, and any decision you make for your family is going to be better than a decision a judge makes for your family. Two is you don't have to have all the answers before starting the process. And again, whether it's me, whether it's another attorney, they're going to help you think through good guardians and good trustees and the considerations. I play devil's advocate with my clients in a follow-up call when we work through the questionnaire. And I ask all sorts of rude and intrusive questions about their choices of guardians and trustees, just to make sure we've made the best choices we can of the candidates we have. But again, don't give up on the process because of you have to make these hard choices, which a lot of people do. They just kind of put it to the side. And so even if you don't have good choices, you still need to make choices. Let me give you my email address if you have questions. It's down here at the bottom. It's just dj@jlaw.com. And I think I have to stop my share to see the chat. So let me, if you have questions, instead of calling them out, if you can just put them in the chat box, I'll be glad to read them to the group and then answer them as best I can.
DJ, I have a few questions that were direct messages to me, and I'll read them out to you.
Okay.
First question is, my understanding is that you should not direct monies from special needs child's money from his social security funds go directly into trust. That would be first person special needs trust. It's kind of a hard question to read out.
Well, so I understand the question. So I think the question is, if your child's getting social security cash benefits, do you want that to go into a special needs trust? The answer is no. That social security money is first party money that belongs to your child. So if you take that first party money and you put it into a third party trust, it poisons that entire third party trust and it all becomes first party money. So for that social security money, what I encourage people to do is first use it first and foremost for whatever your child needs. Keep it in a separate, savings or checking account. Then if you have money left over and you want to make sure you don't hit that $1,000, resource limit, you can always move it into an ABLE account, which is another kind of shielded option, kind of like a special needs trust, but important differences that I'm not going to get into today.
Thank you, DJ. Another direct message was general estimate of testamentary versus standalone trust.
So every family, every lawyer does it differently. I can just speak for what we charge. And so what we charge is, if you were on the call at the beginning, that list of documents, that's our package. It's your will, it's your trust, it's your advance directives, it's financial powers of attorney, it's your guardian letter, it's your protection cards. It is help with guardian and trustee. It's all of that. So if you do a testamentary special needs trust package with us, the total for everything you will need is $3,500. If it is if you want a standalone special needs trust package, and this is again everything included, it's $4,500. That also includes a trust for a typical child, if you have one. That's included in that price. So if you have a typical child who's too young to manage a large sum of money on their own, if they come into it, that does include a testamentary regular trust for a typical child.
Thank you, DJ. Another question is, my husband and I are legal guardians of our 18-year-old son, but we don't have a backup. Can we include a backup on our will?
Oh, absolutely. So, and I would encourage you to do so. Sit down and come up with a list of all your potentials, and you're gonna have that hard conversation. I highly encourage having a stiff drink before you have the conversation, and just make the best choices of the people you've got. There is a group I'm actually talking to tomorrow. I'm not going to give out the name now because I have not really vetted this group yet, but I know other attorneys use them. That is basically a care coordination company that kind of fills in for a lot of the functions of a guardian. I'm going to do that. I'm going to talk to them tomorrow, and if it turns out to be a good fit, Jade, maybe I'll just kind of do a quick update on that. But yeah, I would absolutely update your will to put in guardian backups.
Thank you, DJ. Are you taking new clients at this time?
Yes, I've got a special needs kid, so I need to leave some money for him. So yes, we're taking clients.
Lots of people have asked if this recording will be available. Yes, it will be available on the Focus website, which is focus-ga.org. Under parent support, we have many workshops, many actually done by DJ as well, on there, and it will be there hopefully by the end of tomorrow. DJ, another question is, what is your email address and contact info again?
All right, let me share the screen again so people can just jot it down. All right, so it's down here on the bottom. Firm number is 678-325-3872. Email address is dj@jeylaw.com. And Jade, I'm going to put something else out there because I know someone had asked about cost. One of the things we like to do for people, we do a fairly detailed client consultation that goes over a lot of what I just went over today. But you know, answering your questions as we go, and in particular to your family, but talking through all the documents and, you know, kind of what's the best fit for your family. Those consultations take a little over an hour. We do them by Zoom. We do charge for those consultations. It's $200 for the hour. But if the family ends up hiring us to do a plan for them within 30 days of the consult, we do apply the $200 to the cost of the plan. I do encourage families to do the consult. If you hire us, that's great. It turns out to be a free consult because we apply the $200. If you don't end up hiring us, you've gotten $200 of attorney time, which is a pretty large discount over kind of what my normal rates are. But you're going to walk away with a really good education of what, at least I think, your needs. I'm going to answer your questions. And even if you go to a different attorney, you have the vocabulary and the options to have a good discussion with that attorney about what your plan would look like.
That's great information, DJ. Thank you.
Yes, I'm Esme Johnson. Someone gave the website for Focus. Could you repeat that, please?
Yes, the website for Focus is Focus, FOCUS-GA.org.
Okay, and you say that this recording will be on this website?
Yes, all of our recordings are on the website under parent support for workshops.
On the parent support for workshop. Okay.
DJ,
Okay.
we'll go to the next question. They're still coming through direct messages. Is that we are a non-immigrant family in the U.S. We do not have family here. How do we choose a guardian? I want my child to be in the U.S. owning benefits that he has here.
On the parents.
So I've got, and I'm first. My parents are here, but they're elderly, and so we've got the same challenge, and it's going to be what I told the folks who left the previous question. You come up with a list of all potentials, and you make the best choice of who those potentials are. For my guardians and my trustees, none of them are family members, because I wanted to pick the best person for the job, who knows my child, who loves my child, who has the patience, who has the time. And that turned out not to be our blood relatives, who admittedly just don't really seem to have a lot of interest in my son. And so I want the people who care about him and show that now. It's hard. It's a big ask for people who are not family, but not a single one of my guardians or trustees is a blood relative.
Thank you, DJ. Next question is, when parents are divorced, does each parent establish a separate special needs trust?
That's a great question, and that is one that I'm getting more often. I mean, sadly, we all know that the rate of divorce in special needs families is pretty high, higher than the general community. It comes down to this: you can use a single trust if you can agree on who the trustees will be. And with divorced couples, this is sometimes turned out to be an issue, because even if they get along, let's say the ex-husband wants his brother and then his dad to be the trustee and then the backup trustee, and ex-wife says, no, I want my sister and my mom to be the trustees. Well, if you can compromise on that, then yeah, you can use one trust. If you can't agree on that, which really turns out to be the case a lot of times, then and you want to have control over who those trustees are, then you would need two separate trusts.
Thank you, DJ. Another question, is an irrevocable special needs trust and a first person trust the same thing?
So a first person trust does have to be irrevocable, but it's not exactly the same thing. You can make a third party trust irrevocable. There are some benefits to that, some tax benefits, qualifying as a disability trust. But anything that obviously is irrevocable, once your money's in there, it's in there. It's not going anywhere. And so if you're funding the trust while you're alive and you start putting money in there, and then you find you lose your job or you have unexpected expenses that don't involve that special needs child directly, you can't get the money out in an irrevocable. With a revocable, you could.
Thank you, DJ. Next, should someone start a college fund, or should that money go to a trust?
So you can use the trust to pay for college. And a lot of this, the bottom line answer to that question is it depends on your tax situation. I'm not a tax attorney. I do not give tax advice. But a special needs trust is taxed like a regular trust, which is not the best tax treatment. So if you do have a child who's going into private school or in a college program, there are tax benefits to a 529 plan that is not considered that child's resource. So you can do that, or you can use an ABLE account to pay for that child's education. That again, if you know that child's going to school or going to a college program.
Thank you, DJ. This next question, I hope I can say it correctly. The child has CP. Owning our visa status and not being citizens, we were advised we should not get Medicaid, even though he is a citizen. It will affect our green card processing later. Is this true? Could you suggest anything? I'm not sure that this is under guardianship or trust, but I don't know.
Yeah, no, and I will definitely punt on that. I've never heard that before, but I mean, I would consult with an immigration attorney. They should be able to tell you pretty quickly the answer to that, but I do not know the question.
Thank you, DJ. What's the best way to deal when there are few assets in the child's name, specifically life insurance set up by the grandparent and both Roth IRA set up before we were aware of his special needs? At age 15 now, what's the best way to deal with few assets?
So if the asset is in the child's name and owned by the child, before they turn 18, you'll want to move those assets into something that's shielded, whether it's a first person trust or an ABLE account or out of their name. A lot of that has to do with transferring assets out of the child's name. There's a look back period of 5 years for Medicaid. And so you can't transfer anything. If you transfer anything not for value or into one of these shielded entities like the ABLE or Special Needs Trust, Medicaid's going to look back 5 years and say, we're going to count that against you. Or you can use it, just use it for that child's benefit and start saving money where you would have otherwise paid for it and put that into a shielded third person special needs trust.
Thank you, DJ. Will we need a separate trust if we have multiple children with special needs?
No. Multiple special needs kids can share one trust. The big decision in that is there are two ways to handle the trust. You can do essentially what's in an account for each child under that trust. And so, 10,000 in account A in the trust, then 10,000 account B in the trust. But then A is for only child A and B is only for child B. Or you can just pour it all in there and say, trustee, we're going to, if one child's needs are greater than the other, we trust you to handle that. And just caveat, that is only for third party special needs trusts. If you need a first party for whatever reason, that can only be for the benefit of one child.
Thank you, DJ. Do you still have time to answer questions?
Yeah.
Okay, great. What is the wording grandparents should use in a will to direct money into the trust that the parents have started?
So it is generally, and I'm quoting here, but it is leaving whatever, let's say 30% of my estate to the then acting trustee of the DJ Jeyaram Special Needs Trust established September 29th, 2022 in my will. So it's got to be pretty specific.
Thanks, DJ. So a standalone trust is the only one we can directly deposit money into?
Yes. Because the testamentary doesn't exist yet. But again, I would educate yourself on an ABLE account. I do go into ABLE accounts during the consultations. If you want to start putting money away for your child now, the ABLE account has tax benefits. You don't have to pay the extra money to build a standalone right now. The real big downside to the ABLE is at the end of the child's life, those are first party funds. So at the end of the child's life, to the extent Medicaid has paid for anything for that child's care, Medicaid can take what's left in the ABLE account. But if you have a child who has special needs, but not any necessarily life-shortening conditions, then an ABLE account might be a better option for you than depositing in the special needs trust. ABLE accounts are capped at $16,000 per calendar year, and at $100,000 total, Medicaid benefits, some SSI benefits get suspended.
Thank you, DJ. Can you build guardianship for a child when they turn 18 plus into a will, or should you wait until they are 17 to add that?
So you want to add guardians as soon as possible, because if something happens to you when your child's still a minor, you want to make sure the people you have chosen are taking care of that child. You can only go through the guardianship process to get appointed as guardian after your child. You can file at 17 and a half, but it only becomes effective when your child turns 18.
Thank you, DJ. What are the typical funds associated with having a living special needs trust annually?
Oh, the costs. I think that means the costs. It really depends on two things. One, who your trustee is. If you are choosing a corporate trustee or a bank as trustee, as soon as that trust is funded, they start charging something for it. I always recommend a friend or family member, someone who knows and cares about your child. Even though that trustee is entitled to compensation, in my experience, most of them don't take it out of the special needs trust. So nothing there. There may be some costs. Most trusts will retain a financial planner and a CPA to make sure that things are invested right and that tax returns are properly filed. So there's that cost. And then whatever the account costs are at whatever bank you keep your trust accounts at. So, but that really should not be too much.
Thank you, DJ. Can funds in a 529 be transferred into a special needs trust?
So from the 529 can't be into the special needs trust, but they can be transferred into an ABLE account at $16,000 per year with no tax consequences. An ABLE account's tax designation is actually a 529A. So they're very similar animals, which is why you can roll over.
Thank you, DJ. My son's father and I co-parent our son. I'm going to look into the Katie Beckett waiver. Would this be transferred to my son's father, or would we both need to apply?
So you're applying in the name of the child. So once your child qualifies, no matter who the parent is, the child should continue to qualify.
Can a 529 account change into an ABLE account?
You can transfer it at $16,000 per year with no tax consequences, but as far as I know, you can't just change the designation wholesale.
Thanks, DJ. Do we make a special needs trust the beneficiary on any insurance policies?
You want to make it the beneficiary for whatever part of that policy you want to go to support your special needs child. So for example, my life insurance policy says primary beneficiary 100% to my wife. My contingent beneficiaries are something like 70% to the Kai Jeyaram Special Needs Trust, 30% to the Emmy Jeyaram regular trust.
Thank you, DJ. And of course, you've got a ton of love on the chat boxes of thanking you for your time today. Thanking you for sharing. Another question, Tina, it says that we want to leave our child. Can you type the rest of your question into the chat box and DJ can answer that for you?
So unfortunately, I'm not able to see the chat for some reason.
Yeah, most of them are coming through direct message versus going to everyone or to you.
Yeah, I don't see anything at all. So.
That's okay. I think that's because they're all coming direct message to me.
Okay.
Otherwise, you're still just getting tons of love of just being so helpful and thanking you for your time.
Oh no, absolutely. I love doing this stuff. I love knowing the families are kind of squared away as much as we can be in something that's very difficult. But if you don't have something in place, I encourage you to put something in place. I can almost guarantee once your documents are signed and squared away, you're going to sleep a little better.
Thank you, DJ. You're very right. We don't have any other questions coming through other than just love notes for, again, thanking you for your time. And again, this recording will be on the Focus website, and I'm sure DJ will probably share it again at some point. So any other questions that anyone has, you're welcome to email DJ directly. He's, as he's mentioned, he's always available to families, and he is taking clients. DJ, anything else?
No, I think that's it. Thanks for your time. I know it's a beautiful day outside. Thanks for spending it inside with me.
Thank you, DJ. We just thank you for sharing your knowledge with us. We appreciate it. And the good news is we'll be seeing you again sometime soon.
All right. Y'all take care. Have a good day.
Thank you all.